Oh. So are both parties ready to proceed, State?
Yes, Judge, I would like to reconsider the argument about the single fact that there's some instructions that the defense is requesting to include the mistake of fact offense, but I do have a case that I believe is on point that addresses the issue. I did email the case to the defense yesterday. I just learned that he has not had a chance to review it, so I'm gonna print it out for him and then I'll for the court as well.
Oh, no, I'll hear your argument.
So one based on the case of Court of Appeals from Austin, third district, the Douglas. In 2011, he commits a new offense which gets enhanced to a felony. That case, he ends up getting convicted. He ends up arguing, appealing to the the Amarillo Court of Appeals. The Amarillo Court of Appeals ends up reversing the case for insufficiency of the evidence, and he gets released from TDC. When he gets released from TDC, immediately the next day or 2 days after, he goes to the XY, which is the complainant and the protected person, and her place of employment, which is the protected address, and he gets arrested again. He goes to trial on that new case again. It's a BPO with 2 priors, it's a felony. He gets convicted. In that trial, he admits that there was a protective order in place, and that he admits that he had the intent to go to the job, to the ex-wife's place of employment. So he argued for a mistake of fact defense because he was under the impression that the Court of Appeals, because the Court of Appeals had reversed the BPO case earlier, that the protective order was also thrown out. So he was under the impression that there was no protective order, which is why he went to the ex-wife's place of employment. So he ends up getting convicted, the case gets appealed, which is the case that we have here today. And the court ends up going through the analysis and says, and looks at the statute of BPO. And the statute says that the mens rea relates to the conduct of the violation, not the actual protective order. So it's not whether he intentionally or knowingly violated an order of district court, it's whether he intentionally or knowingly committed the acts that are enumerated in the protective order, like committing family violence, possessing a firearm, communicating with the complainant, and in this case, going within the residence or the protected place. In this case, we have similar circumstances where the defendant has stated that he did not know that the protective order was active. He says that it was for only 1 year. But the issue here is not whether he intentionally or knowingly knew about the protective order. The issue is whether he intentionally or knowingly went to the location, to the residence. So because the mistake of fact has to go to the culpability, the rule is that it's the defense says it's the defense prosecution that the actor of mistake formed a reasonable belief about a matter of fact if this mistaken belief negated the kind of culpability required for the commission of the offense. So culpability required in this offense is intentionally or knowingly going to or near the residence of the protected person, the protected address. In this case, he testified that he went over there intentionally and knowingly because he went to go get his mail. We're not going to debate here whether or not he did intentionally or knowingly violated the protective order because that has already been addressed in the civil side. We already know there is a protective order in place, and the legislator intended on the state only proving the mens rea as to the conduct that he committed when he violated the protective order, not whether or not he knew that there was a protective order in place. He should already know that. That's why there was a civil case in place. There was notice, there was opportunity heard. He went in front of with an APA and he signed the protective order. That's already done for. The protective order is already in place. If he's gonna litigate as to whether or not it should have been a year or 2 years, that's something that is done in the civil side. In the criminal side, the only thing we have to prove intentionally and knowingly is whether he actually went to the residence. And his mistake of fact is not whether or not going to the residence. The mistake of fact that the defense is arguing is that he thought it was a 1-year protective order. So therefore, he's not entitled, according to this case, and of course, according to the statute, he's not entitled to a mistake of fact instruction. So we ask for reconsider and not include the mistake of fact instruction.
All right, defense.
It's uncontroverted on the testimony that my client went over there on mistaken belief that based on what a judge had told him that the protective order was finished, null and void, done, that he could be there. And I think that goes to clearly to the defense of mistake of fact. We believe we're entitled to that charge.
That's not a mistake of fact. That would be if anything a mistake of law, but I don't think mistake of law even applies here either. Because he's relying on a public official, which in this case it would be a judge. I don't think mistake of fact applies in this case. That's just our argument.
All right, thank you. Does anyone know, can you check with Deputy Lord to see if the jurors are here?
You're not.
They're not?
We're missing 5.
Ah.
Must have gone down the bridge there.
But in the meantime, I'm gonna connect the stuff and test.
All right.
By jurisdiction.
All right, thank you. All right, RC Curtis.
I'm gonna.
All right, thank you. Ethan Rosales.
You can make yourself.
I'll do my 620s. Or services. And then I go around the courthouse. I turn the corner on the 8th, you know, where it's spring. Didn't click. It's not too dead. I mean, I contacted.
All right, Cindy, we're gonna go on the record. All right, with regards to the state's argument, the court has considered the state arguments. The court is aware of the case law. That will be denied. Any other objections to the charge? Defense,
No, Your Honor.
state?
No,
We do 6 months after being 5. I'll have that, no, my training counts. So the whole 6 months I was gone. Let's say you want to have 2 safety training. Sir, officer, 2, 3. Or I would. I'll just do it last 8 weeks. I think, and after that, I can start. I'm trying.
Yes. It is.
Everybody's here? Oh, let's bring them in. All right. Are both parties ready to proceed?
Yes, sir.
Does anybody need a time announcement?
I have a 1-minute warning.
All right, so are you doing the entire closing?
No, just fix.
All right, so when you say a 1-minute warning, you mean you want me to stop you at 1 minute or tell you 1 minute has elapsed, 60 seconds?
Like 1 minute until the end. 1 minute we're ready.
With me.
For me,
Okay, from the 10 minutes?
yes.
Okay,
I'll probably just take a few minutes and I'll reserve the rest of it.
okay. Uh, So to be clear, both of you are doing closing.
Yeah.
All right. So you want me to let you know when you only have 1 minute remaining of the 10 minutes? Okay. Oh, all right. I understand now. In defense, you don't need a time announcement.
Oh, yeah.
All right, let's bring them in.
All right, for the jury.
Oh, please be seated. All right, ladies and gentlemen, I'm going to read to you what's entitled the charge of the court. You do not have to memorize this. A copy of it, well, the original will be given to you when you begin your deliberations. Charge of the court. Members of the jury, the defendant, Richard Thomas Casanova, stands charged by indictment with the felony offense of violation of certain court orders in a family violence case alleged to have been committed on or about April 20th, 2024 in Bexar County, Texas. The defendant has pleaded not guilty. 1, our law provides that a person commits the offense of violation of certain court orders in a family violence case under section 25.07 of the Texas Penal Code if, in violation of an order issued under chapter 85 of the Texas Family Code, the person knowingly or intentionally goes to or near the residence of a protected individual. The offense of violation of a certain court orders in a family violence case is a felony offense if the person has previously been convicted 2 or more times of the offense of violation of certain court orders or conditions of bond in a family violence case under section 25.07 of the Texas Penal Code. 2, you are instructed that Texas Family Code section 85.001 and section 85.005 are in chapter 85 of the Texas Family Code. Under Texas Family Code section 85.005, parties to a proceeding may agree in writing to a protective order. Such agreement is subject to the approval of the court. Under Texas Family Code section 85.001, at the close of a hearing on an application for a protective order, the court has the authority to find that family violence has occurred and to render a protective order that is in the best interest of the person protected by the order. 3, family violence means an act by a member of a family against another member of the family that is intended to result in physical harm, bodily injury, or assault, or that is a threat that reasonably places the member in fear of imminent physical harm, bodily injury, or assault, but does not include defensive measures to protect oneself. Assault is committed by a person if that person intentionally or knowingly causes bodily injury to another. Bodily injury means physical pain, illness, or any impairment of physical condition. Family includes individuals related by consanguinity. 2 individuals are related to each other by consanguinity if one is a descendant of the other. 4, a person acts intentionally or with intent with respect to the nature of his conduct when it is his conscious objective or desire to engage in the conduct. A person acts knowingly or with knowledge with respect to the nature of his conduct or to circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. 5, it is a defense to this prosecution that the actor, through mistake, formed a reasonable belief about a matter of fact if his mistaken belief negated the kind of culpability required for commission of the offense. The term reasonable belief means a belief that would be held by an ordinary and prudent person in the same circumstances as the defendant. Therefore, if you believe from the evidence beyond a reasonable doubt that the defendant, Richard Thomas Casanova, committed the acts alleged, but you further believe, or you have a reasonable doubt thereof, that at the time of the alleged acts, he had through mistake formed a reasonable belief about a matter of fact, to wit, that the protective order had ended and that said mistaken belief negated the culpability required for the commission of the offense as defined in this charge, you will find the defendant not guilty. But if you believe beyond a reasonable doubt that the defendant, Richard Thomas Casanova, had not through mistake formed a reasonable belief about a matter of fact, to wit, that the protective order had ended or that such belief did not negate the kind of culpability required for the commission of the offense as defined in this charge, you will find against the defendant on this defense. 6, now if you find from the evidence beyond a reasonable doubt that on or about April 20th, 2024 in Bexar County, Texas, the defendant, Richard Thomas Casanova, did intentionally or knowingly violate an order of the 150th District Court of Bexar County, Texas, dated the 2nd day of June, 2022, under cause number 2022 CI 09053, issued under the Texas Family Code Section 85 by intentionally or knowingly going to or near the residence of Crystal Casanova, and it is further presented in and to said court that before the commission of the offense alleged above, Richard Thomas Casanova had previously been convicted 2 times of an offense under Section 25.07 Penal Code, in that on the 15th day of February 2023 in the County Court at Law Number 7 of Bexar County, Texas, and cause number 684790, Richard Thomas Casanova was convicted of the offense of violation bond protective order. And on the 23rd day of March 2023, in the County Court at Law Number 7 of Bexar County, Texas, and cause number 702830, Richard Thomas Casanova was convicted of the offense of violation bond protective order, then you will find the defendant, Richard Thomas Casanova, guilty of the felony offense of violation of certain court orders in a family violence case as charged in the indictment. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty. If there is any testimony before you in this case to the effect that the defendant may have previously committed an act of misconduct or an offense, or has previously been convicted of an offense or offenses other than that for which he is now on trial, you are charged that the court permitted this evidence to be introduced for the purpose of aiding you, if it does aid you, in passing on the credibility of the defendant as a witness in his own behalf and the weight to be given his testimony. And you are charged that you may consider such evidence for that purpose and no other. As to the evidence of a prior offense or act of misconduct for which the defendant has not been convicted, if any, you are instructed that you cannot consider said evidence for any purpose unless you find and believe beyond a reasonable doubt that the defendant committed such act or act of misconduct, if any were committed. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet or computer, the internet, any internet service or any text or instant messaging service, or any social media platform, internet chat room, blog, or website to include, but not limited to, Google, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, Twitter, or X to communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Written statements made by a witness to investigators or other officers or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of the trial or during argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by this court in these instructions, are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions, which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given the testimony. But you are bound to receive the law from the court, which is hearing given to you, and be governed by that law. In order to return a verdict, each juror must agree to that verdict. But jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement if that can be done without violence to individual judgment. A unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely based upon the opinion of his fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt, and if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you in these instructions, you will acquit him and say by your verdict, not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty or not guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the deputy who has you in charge. Do not attempt to talk to the deputy or anyone else concerning any question you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the deputy. Any and all communication relative to the case must be written, prepared by the presiding juror, and submitted to the court through the deputy. Respectfully submitted, Judge Stephanie Boyd, 187th District Court, Bexar County, Texas, and suitable forms are attached. State, are you ready to proceed?
Yes, Judge.
All right, you may proceed.
Ladies and gentlemen of the jury. Mr. Casanova violated protective order. How do we know that? Well, let's go over the elements of the offense that I talked about during jury selection. This is the charge, violation of a protective order or bond condition. The jury instructions words it as violation of certain court orders, family violence. It's the same charge, just a different word. These are the elements. On or about April 20th of 2024, that element is satisfied because you had the officer here that testified that that was the day that he responded and he was working. Happened in Bexar County, Texas. Again, the officer told the officer at the San Antonio Police Department told you, address is in Bexar County. The defendant, we know that this is Richard Casanova because, again, Officer Rivera was on scene and yes, I need him. That's the person that I arrested. Violate an order under the 150 District Court. Here's the order. Okay, it's on the civil side. It's civil side protective order, but it has criminal consequences. Violate the order, you get arrested. But it's obtained in the civil side, and all the details are in here. You can compare them. Intentionally and knowingly going near the residence. We know that because again, the officer testified to that, and he said yes, he was at the location. I arrested him. He was in the backyard. We know it's within 200 yards.
We need a deputy out here now.
Excuse me.
Code 2, fourth floor, 18, code 2.
All right, everyone, the deputies will take care of that. All right, ladies and gentlemen, do y'all need a break or you wish to continue? All right. All right. So you need not have any concern about what's happening across the hallway. The deputies will take care of that. All right. So for the record, does anyone have any concern? All right, and are you all ready to continue?
Sure.
All right, and State, let me give you I'm going to give him a little bit more time because some time elapsed while the deputies were going across the hallway. Just one moment. All right, you may continue.
Intentionally going near the residence, we know officer testified, and of course, finds on a mission, he also testified towards the location. So the other elements is he's been convicted of 2 prior, right? And we have judgments here that show that. Now, I do want to caution you, the first judgment, the older one, that is violating a no contact order. A no contact order is a condition of bond that is issued in a criminal case, and he testified. After I told him of terrorist threat, he was placed on probation for the terrorist threat. That no contact order of a bond he violated, which is what the charge is about. The second conviction is a violation of the protective order, which is what we have here. Both are the same, it's just different wordings, but it's the same for the purposes of the legal conviction. Now, keep in mind that the date that is listed on the elements is the conviction date. not the offense date. The offense date, which is the date of the offense, is going to be up here, right under the name. The conviction date is gonna be here on the jacket of the judge, so that way you don't get confused. You'll probably notice that when he was terminated from his probation on the first instance, 3 days later, he picked up the second case. You'll notice when you compare the dates. So burden to prove, we talked about beyond a reasonable doubt as well, and I gave you an example of the movie theater. It's not beyond all doubt, it's beyond reasonable doubt. I also talked about what is not evidence. Do you remember when I mentioned that the defendant's criminal history is not evidence? Well, I did talk about it a little bit, and the reason is because exceptions apply to that rule. And that is, the defendant has the right to remain silent, right? But once the defendant takes the stand, and if he testifies that he's never committed a crime like he did, he said, I never committed a crime to get a protective order. Well, I have evidence that contradicts that, and that's when I went up to him and I asked him, well, hang on, isn't it true that you got convicted of this? Isn't it true that you're convicted of a felony? Isn't it true that you're convicted of these 2 priors? And that's when I pretty much get him to say, okay, yes, that did happen. So we do that also with an officer. When an officer testifies, they have a police report. If the officer doesn't testify to consistent with what's in the police report, they come in and say, well, isn't it true that on your police report you stated this, okay? Jury instructions. I do want to point out on page 9 of the jury instruction says, you must not let bias, prejudice, or sympathy play in reaching a verdict in this case. This is a guilt innocence case. This is just here to determine whether or not the violation was committed, okay? So we're not here to talk about other thought, it's just whether or not it happened. Now the verdict, many of you, one of the many reasons why protective orders exists is to deter the crime. And the way that you do that is by keeping people away home, okay? We don't want people like the defendant to be in a position when you go inside and be able to hurt people, especially the ones that are protected by the protective order. There is no requirement that there needs to be violence. There's no requirement that there needs to be the destruction of property or somebody getting hurt. The protective order is very clear. Sure, one of the conditions is if he commits an act of family violence, that's a violation, but that's not the only thing, that's not a requirement. It says here, all you need to do is just go in 200 yards, and that's important because when I asked the question, the majority of the jurors raised their hand that that's the most important one, and if I'm not mistaken, 9 of you in this jury mentioned that as well. Okay, and that's why, because we want to protect our home. Our home is our shelter, our safe place. It doesn't matter if you have to get assaulted. The fact that you're in or near my house, that in itself is a violation, and that's why the protective order protects against that. But it only works if we enforce it. And here's what we got. So I asked that you give this protective order purpose and wait by holding them responsible and finding it.
All right, defense, are you ready to proceed?
Yeah, be all
No problem.
right. Hey, please, the court opposing counsel. Apologize, ladies and gentlemen, my back's hurt. We started in voir dire of a simple fact that my client standing at a point of presumption of innocence. That presumption of innocence put him in a place where you are sitting at that time, where you're equally innocent of this charge. Question was, has the state taken us from a presumption of innocence to a point of beyond reasonable doubt? The new thing that's in this, especially in this court, in this case, is that not only do we have that question to solve, but we also have an issue of defense. Defense has been raised in this case, and that's been put in the charge on page 4. And on page 4, you're going to see in the middle of it that it says mistake of fact. Read this very carefully. This is something that my client was relying on when he went to that residence. He testified to that fact. Let's go over reasonable doubt first. We have to go over one and then the other, because the state has to overcome both of those hurdles today. Because even if they can possibly prove beyond reasonable doubt, and I don't think they can, they still have to jump over the hurdle of defense. Okay, so if you find that he did not complete that trail of going from the presumption of innocence to guilt beyond reasonable doubt, that means my client's not guilty. If you find that they did complete that, they still can't overcome the burden of mistake of fact as a defense, and my client's still. Let's talk about far as reasonable doubt. My first testimony came from the ADA Valerie Elizondo. She's been in the protective order unit about 5 years. She handles a lot of cases. I think she handles about 100 a month. I think she's there 6 months, handles about 600 cases. She doesn't remember meeting with me. I can't blame her, because that's a lot of faces to have to handle. But she had no notes from a meeting with them, because this was an agreed order. She didn't make any notes as to what was agreed to, length of the matter, anything like that as far as the protective order. She didn't see my client sign the order. She can't testify, especially, which is one part, there's no evidence that my client was ever received that signed order. That was supposed to be sent to them by certified mail. It's a simple proof matter, okay? Do that in every case like you're supposed to. Send it out, person signs for it, got proof to show the court, and he got this order. Okay? There's no such proof here. The next person that testified, Kevin O'Neill, ECLSO deputy, at service. Another man that handles a lot of cases. He handles 8 a day, sometimes five times a week. Of course, he can't recall everyone in this service. Not too significant. He didn't recognize my client. Not too significant. That's understandable. Of course, he doesn't make any notes when he makes the service. Doesn't ask for any particular ID. Doesn't particularly ask for driver's license. Doesn't ask for social security. Nothing like that. He said, "Hey, I just come up here. If I say, ask who you are, and you say that's who you are, that's good enough for him." But one of the key things that came out of his mouth was what? I'm tired. That's something for you to do. Next was the arresting officer, Stefan Herrera. Been on the police force quite a few years, he said 18 years. When he got to the house, didn't come, he knocked on the residence, didn't get an answer, went around the side to the back. When he got back there, what did he see? He saw my client there on that. Immediately assumed he was doing something wrong. Didn't wake him up or anything, didn't say, "Hey, you live here, why are you here? You know, you reside here, is this your house?" None of that. Let's cuff him. We got 2 big police officers against my short little client. Let's just cuff him, drag him to our car. I think he's presuming suspects. Didn't even ask him. The thing that was significant about this was, what did my client tell him that day? That's something my client's just saying here today on the witness stand. What did he tell him like that? "Hey, I live here. Hey, the judge said the order was over. Protective order was done. Judge said I could be here." He's telling him why he's there. He's under a mistaken fact. That's why he's there. Next was Raul fingerprint expert. The only thing that I looked at that was significant, I thought, from his testimony, that the fact that he compared fingerprints from today, other day, ash prints. When you look at those 2 judgments, and you'll be able to take it back. Here they are. Look on here, okay? Whenever you're convicted, there's supposed to be a thumbprint here and a signature. Right. Finally, my client doesn't have to testify. That's his right. He decided to take the stand and tell you what happened in his own simple words. He simply told you that he went to the house once. He's gonna get it from all. Right? I said, "Well, why don't you just go inside your house? My keys are inside the house." Well, so he tried to go enough, around back. Didn't try to cause a disturbance, didn't try to break a window, didn't try to throw rocks in the house, didn't disturb neighbors, didn't try to make a ruckus or anything like that. Went back, they said, "Well, why'd you wait back?" "Well, I was waiting for somebody to show up," okay? Which is reasonable. Then when the cops got there, once again, what did he say? Told them that he lives there. He told them that the case is over, that the protective order was done, okay? That the judge told him he had a right. That was his testimony today. That was his statements in time of police force. It's very reasonable. Now, if you look at those 2 violations of conviction and talk about the date of the offense, when did those happen? Those happened within 1 year of that protective order. Okay? Why is that significant? Because, as my client testified, he believed he was under a 1-year protective order. Both of these violations happened within 1 year. We went to the house this final time that we're in trial for. That was almost at the 2-year period. Because in the June 2022 protective order, the allegation of the offense occurred supposedly on April 20th of 2021, nearly 2 years. So he, like I said, he felt he was in the clear. The order was over, 1 year had gone, even the judge had told him it was clear. So, but I asked you to consider very carefully for all these possible reasonable doubts that are here, as well as his defense of mistaken fact. which is uncontroverted. The judge, when he was talking about, he said, the judge mentioned who the judge was, Judge Lear, county court 7, a law judge here in the courthouse. She didn't say that. Why did the state bring her in here and tell her? Very simple, very simple. They did. He told everybody and testified that this stuff, that protective order was over, he was under that belief, was not negated at all. I asked that you find my client not guilty, not only for the reasonable doubt that he has that's behalf of my client, myself. Attention.
All right, states you have 5 minutes.
About this trial by asking, what are protective orders for? They are to prevent situations just like this. They're here for this defendant and people like him because he refuses to accept the fact that this protective order exists and he continues to harass this family. Protective orders are for the protection of this family, for their security, for peace, to prevent him from going into the backyard and sleeping on the porch. They are not just a piece of paper. And that's what he wants you to believe. That this is just a piece of paper that his word alone can undo. Is that what our standards of community are? That we can just undo a court's order with a thought, just a word? After he violated no contact order, a protective order, twice. We see the judgments. He has convictions for them. He also had a terroristic threat against those same people, criminally negligent homicide. Now, he had the opportunity to consult with an attorney and have a hearing, but he didn't. He agreed to that protective order. He never said, he said that he also never received a copy. But we heard that copies get sent to the email that he used that day on Zoom. And even if that were true, even if he didn't receive that copy, it is effective once it's signed. But we're not here to relitigate whether or not this protective order was effective or not. We know it was. We see it. But now he wants to say that he didn't know if he signed it. That's just not reasonable. We heard him testify that he did go to the property. By his own admission, he went to the property to get his mail, but he was on the back porch. Does that sound like he's being truthful? He said, police said no to an escort. Why? Because he was not allowed to be on that property. Now, he stated that Judge Lita told him that the protective order expired. That was when his case in County Court 7 was taken care of on February 15th of 2023. Which, if it was expired, or if it was null and void, like he said, we would have had to have some sort of writing. I mean, this is the legal community. We need that. Something signed, an order. I cannot give you something that does not exist. But let's go back to the date, February 15th of 2023. If he truly believed that the protective order was null and void, he didn't go back on the 16th, he didn't go on the 17th, he didn't go on the 18th. And he told you, oh, well, I thought it expired after a year, which would have been June 2023. But then he didn't go to the address until April of 2024. Why did he wait? What was stopping him from going to that address for almost another full year? Because he knew that he was not supposed to be there. And he took that chance, but he got caught. He told you all these things were there, and that he was living there, but he didn't have a key. And he hadn't been at the residence since 2022. Is that reasonable? Was it even reasonable that he even went to the address in the first place? We have these convictions, these protective orders, these no contact orders that say that these people did not want him living there. It's not reasonable for him to believe that he could just go to the residence. He doesn't get any points for testifying. You get to judge his credibility like any other witness. So then ask yourself, what evidence was presented to corroborate what he was saying? The evidence we've shown directly contradicts what he is saying. Mistake of fact has to be reasonable.
1 minute.
And is what he's saying reasonable, or is it just something that his words can written? The protective order is so much more than a piece of paper. It is a tool that this judge decided that this family needed protection from Richard Casanova. Follow the evidence. We have judgments, 2 previous convictions. He knew that he was not supposed to go to this residence and continued to go there. Now, on April 20th of 2024, he went out to that residence on the property within 200 yards, violating that act. Protected his family. We talked in jury selection about why people don't want to testify against their family. It's hard to come against their father, a family, somebody you grow up loving, but that doesn't mean that they don't need protection from them. Protect our community. Our standards are higher than something that can be ripped in half by someone who needs to be held accountable. $500.
All right, ladies and gentlemen, Deputy Laura will take charge of you. And we can go off the record. State defense. I like it. I can see you try more to this. Yeah.
That was very good.
All right, and state.
Yes.
You just turn off your equipment. Thank you. And Norma, David McLean is going to be handling the appeal that is on Dixon. So if you place him on that. Yes, yes,
So the other one I just said, I need to have a hearing.
sure. Yes, what one needs to have hearing?
It was on Tyler Ray. It was on Amanda.
Amanda who?
Does it have to be a time before the 17th?
All right, let me see. Oh, no, all we need to do is appoint someone.
She said she doesn't understand why. Not.
All right, thank you. You can see if, I don't know if Callahan still does. If you want to see if Callahan wants to.
Okay. You want me to tell them to hold off on the email then? Cause I said, no, Mac already.
Oh, if Matt can get someone immediately, yes.
Mac is the one that's.
Are they gonna get them immediately?
That's what I told her.
Yes.
And I sent over that Barbara said it needs to be done before.
No, no, no. Tell them that I need to know of an attorney being appointed to that case no later than tomorrow. It should be easy to do. Yeah,
I
so,
mean, I could have done it, but.
yes, yes. Mr. Klein in custody, they need to bring him out.
It's off record. I have to be in federal court at 1.
They're gonna bring him out.
Yeah, there's,
Yes,
I've conferred with the state already in this matter.
just tell them, you want your client brought out.
He's waiting on the other one.
Yes.
Wait, I think that one thing's.
Let me see. State Defense, if you'll go over the exhibits with the court reporter. Oops.
Yeah.
Got your little.
Which one is it?
Hanging lights on. Yeah, but it's like, these two, I got, what you go? Yeah, I'm looking back, I go back, what you do. I think, it's like, really muscle spasms, right? But I said, well, fine, I got it. That's, oh, it's hard.
Lisa Park. Park.
Oh, okay.
Like seriously, right? Yeah.
All right, thank you. If you'll make sure that Deputy Laura has them. Oh, and Sydney?
And Garth? Okay. Okay, thank you.
Well, the Venus Fernandez, so I don't know if it's Marcos or Venus.
That is a good point. I don't see how to manage.
So, they would.
It seems like the point is all of the ideas like or
Yes.
No, because you're they are.
And your.
There he is.
You're.
The man we've been, the man we've been maligning.
Or.
Always straight. Always straight, second row top. The first row straight ahead, second chair. Right here.
Yes. I don't know why they've started doing that.
I'm not reading this. Let's go with it for now. I just put all that in 1 minute. Just keeping you right. About the ones that are actually really big. Oh, okay. My next. Guards, guards out there? No, you need guards out there? Is this?
Hey, that's the one you love. Take them all one eye right.
I called it a code because it's.
Call it, but then you. That's good.
Yeah.
Go back.
I'll take care of it.
Okay. I'm going to my house.
Approach on
Yes.
wrong motion.
I gotta chase this.
And Alexander Rodriguez is also.
How are you doing?
Oh, I'm doing great.
Trying to get several things at once. What time do you anticipate having the panel and let's pick?
Well, my understanding is that Charles may not wish to proceed based upon evidence that's been handed over to him. So if somebody wants to see if Mr. Bunk has finished with his jury trial, and then I will hear things.
Yes, ma'am. I will check on that, and that's just to try to keep things moving along.
Right, thank you,
Excuse me.
thank you.
Here's the civil commitment. There are closing arguments
Okay.
going on now.
Alrighty,
And I don't mean to ex parte or get ahead, but that motion is to try to fingerprint for identification of the defendant. And based on if the court grants it, then coordinate the examiner.
all right. Well, I'll address it when Mr. Bunk is here.
Yes, ma'am.
You know, I've never watched a violation of protective order trial.
Yeah,
That was interesting.
yes. You know, I always tell people there are certain offenses that are strict liability.
Yeah.
Was it in place? Did you violate it?
You know, the funny thing is, every now and then I'll get a traffic ticket. And my motto is always to fight them, always. And so a couple of years ago, I guess during COVID, right before COVID, I picked up a traffic ticket. And then I was in Vegas and had a Zoom hearing with municipal court.
Mhm.
And so the judge comes on, I had to go into the bathroom to have the lighting and everything just right. That's why I remember this so well. And so I'm talking to the judge and she's like, so they're telling me you don't want to take a plea? And I'm like, no, I don't. And she's like, well, you know,
Yes.
it's a speeding offense and, you know, they're probably gonna find you guilty. And I'm looking at the judge like, and she's like, are you sure? I'm like, well, you know, I believe I have a right to a trial, judge.
Mhm.
And she looks at me and she's like, yes, but then you'll have to get an attorney and you'll have, and I'm looking at her like, well, first of all, I am an attorney.
Yeah.
Oh, and then she starts backtracking. I'm like, is this how you treat everybody?
Mm-hmm.
But well, I mean, you remember Sharon McRae.
Yes. Uh-huh. Okay. You know what?
I loved her,
Oh,
but you know what I'm saying.
Well, I will tell you, I had a motion to suppress in her court. And it was utter nonsense, right? But the state was going forward because my client was a habitual. And what ends up happening is he's leaving a parking lot. And he doesn't signal when he's coming out of the parking lot. And as you know, once you become an experienced driver, it's like, nobody's behind me, why am I turning on a blinker? And so the state was telling the judge, yeah, we're saying they can do that. And so she said, so you're telling me if I were driving and I come out of the parking lot and I don't signal, that means you get to search my entire vehicle. And they're like, yes, that's what we're telling you. And so she's like, not today. Motion to suppress granted. I'm like, thank you.
It's the little things like that that we remember. Judge, I wanted to approach with the prosecutor on Marco Moreno Vasquez.
That's the pull the file.
He's a Spanish speaker. We had reset it. This is the plea deadline today. This is the one where the state gave me an enormous amount, over 2 gigs of video evidence. My investigator's been showing Mr. Moreno Vasquez the stuff, but we haven't completed showing him that. So he doesn't have, and he wants to see everything, and he has that right. So I don't know when the trial date is set, but one way to alleviate today would
The
be
trial date hasn't been set.
to allow him to take a plea up until that date. And my investigator and I will continue to try to show him everything. And as soon as we get an answer, I'll let the state know. This is what we discussed already.
All right, so when will he be completed? reviewing?
Well, there's an outrageous amount of videos. The state has pinpointed for me where we think the
imperative stuff that he sees are. And so I think we'll be able to get to that sooner rather than later, maybe by the end of next week, because there are a lot of videos.
Oh, this is the one with the 1.9.
2 point something, yeah.
Well, he's saying 1 point, you're saying 1.9, he says 2 point something.
Well, there's addition, there's phone downloads.
All right, everyone, we're,
Drive.
oh, I'm just joking. Is this your client here? All right, Mr. Marco Antonio Moreno Vasquez, and we have the
Yeah.
interpreter here. Good morning.
It's Marco Moreno Vasquez. Charges tomorrow. They told us you're only gonna take about 30 minutes, so this is perfect.
I just came out of another,
You are
sorry.
awesome as
Do you need
always.
the cause number?
if you don't mind, Your Honor.
Sure, it's 2023 CR 4371B.
Thank you, Your Honor.
Okay.
All right, Mr. Vasquez, what we were discussing in the presence of your attorney
Right now, on the record,
and the state was about discovery. So my understanding is now, defense, you have all the discovery, is that correct?
I have all the discovery that the state gave me a couple of weeks ago. We've been attempting to show Mr. Moreno Vasquez all of the videos. We have not completed that. He wants to see everything. We want to show him everything before he makes a decision on what the state has offered.
And when are you anticipating?
I'm hoping by the end of next week, like next Sunday, that we'll be able to see everything. I can't guarantee that, Judge. But as soon as it's all completed, I'll contact the state and let them know whether we are going to try to negotiate a deal or whether we are steadfast
All
in
right.
our quest for a trial.
And state, have you already tendered an offer in this case?
Yes, we have.
All right, so what we're gonna do is we're gonna recall you back for December 19th.
Actually, Judge, I'm gone from December 18th on, so can we make it the 17th?
Yes, we'll call you back. We can do the 16th or the 17th.
Let's do the 17th, just to give me that extra day.
All right, so we're gonna come back on the 17th. And on the 17th, you need to let the court know whether or not you're accepting the state's offer, or if you all will come up with some sort of an agreement. If on that date you have not accepted the offer, your plea deadline date will have expired and your next court date is going to be a jury trial. Do you understand? Yes. All right, so we're going to call you back on December 17th. Do you have any questions about this process? No, right. All right, thank you.
Thank you.
Okay. Oh, just 1 second, Ms. Scarehan. The other thing, with regards to the acknowledgement of discovery, has that already been done, or is that an
I
acknowledgement?
think we signed it last time when I picked up the 2 terabyte.
Yes, Judge, I'd have to check in the file.
Well, I have one in the.
Yeah,
file.
it was huge.
So I'm wondering,
It should include everything.
okay, because this one was as of November 12th. So you're saying that this acknowledgement includes everything?
It should, because I mean, well, and I can make another one just to be sure.
Well, no, if y'all want to check, if you can make sure, then if you need to make another one that includes this, if you could have that ready for the 17th as well.
Oh, sure, yes.
All right, thank you.
Thank you, Judge.
Thank you for coming in. Have a great
Pleasure
one.
always.
All right,
Can I
thank you.
have the excuse?
Yes,
Judge, may I
yes.
have a night mag rejection form from the grand jury?
All right. Thank you. How's it going?
I'm doing pretty good.
Thank you.
Thank you, Your Honor.
Thank you.
Okay.
I'm sure I got it. No, I'm sure I got it. Judge, did you need to see me on that?
No, it's just that if you will check with Barbara Paulison,
With who?
Barbara Paulison, because what she needs to do is she's going to prepare an order for me to sign, and I need to make sure that you're on it. And then they have paused all timing as it relates to the brief until someone's appointed.
Okay.
So I just need to get that in.
Was this like an Anders brief or something?
No. Let me go off the record for a moment.
Okay.
And so I'm like,
I had to get creative on this last one I had, because I was sitting there going through and I was coming up against time crunch. I had probably about 6, 7 days left. Digging through it, and I figured out the record wasn't complete. They were like, oh yeah, we're admitting this exhibit 26 or whatever. I'm thinking, exhibit 26, what the heck is that? It's not in there. So I did a motion to compel and extend, and so I got a third.
oh,
It's
wow.
still missing.
Those were the days. And I said,
Just happened.
no more. I ended up having to get off the appellate. Well, because it's just too much to be a solo practitioner in trial. And I was in trial a lot.
Yeah.
Yeah.
And then doing that, I wasn't sleeping.
No.
And that was back in the day
Yeah.
where you had to go to the library and grab some books.
Oh, my God.
Mhm.
And do book
Mhm.
research. So,
Making the copies of the book so you had the case.
yes. Yeah, those were the days.
Yes, ma'am. I remember.
All right, who is here on Fernando Hernandez?
Present, Your Honor.
Which side, Your Honor?
Here. Fernando Hernandez?
He does speak Spanish, so I'll translate.
Okay, no problem. All right, so counsel,
Yes, Your Honor.
somebody, I'm hearing a lot of shaking of handcuffs. All right.
This gentleman moving his legs.
Okay, thank you. So on this case, is your client a citizen?
He's a resident, Your Honor, and I requested a Padilla letter from the MAC unit.
Okay, and have they told you when they will have that done?
Takes like 2-3 weeks, and I requested it Sunday night.
All right, Norma, can you send an email to the MAC and make sure that an immigration attorney evaluates Mr. Fernando Hernandez's case? All right, so where are we on discovery?
Judge, so the defendant has a number of cases. There's 5 indicted, 2 unindicted. On the indicted cases,
Everyone, please whisper.
on the indicted cases, we have turned over all the discovery. On the unindicted cases, I believe if the offer is accepted, they would be resolved, but there's still outstanding discovery on those 2 unindicted cases. And an offer was extended today, a global offer for all
Okay.
cases.
All right, Norma, recall this back for the week of December 16th. We can do 16th, 17th, or 19th, counsel.
19 is fine, Your Honor.
All right, Norma, if you recall this for December 19th,
And it's for discovery?
it's for discovery, it's for the immigration, and it's also to see if you all can reach an agreement.
Yes, I do have an offer on the table, Your Honor, but I do need to, there's a lot of discovery.
Okay. All right, any questions, Mr. Hernandez?
No, everything's fine.
All right, thank you.
Thank you, Judge.
Thank you.
May I take excuse, Your Honor?
Yes.
And may I be excused as well?
Yes, have a good one.
Hi, how are you?
All right, who's here on Jennifer Hernandez?
We have her here, Judge. But we have a verdict.
Oh, okay, thank you. All right, everyone, just give us a moment. Welcome. Yes.
All right, I'll be back.
Just a moment. It's the court's understanding that the jury has reached a verdict in this case. State, are you prepared to proceed?
Yes, Judge.
Defense, are you prepared?
Yes, Your Honor.
All right, you may bring the jurors in.
All right, for the jury.
All right, everyone, please be seated. All right, ladies and gentlemen, it's the court's understanding that you've reached a verdict. Is that correct? And is the verdict unanimous? All right, if you'll hand the charge to the deputy, please. Deputy Laura. All right, the verdict form reads, we, the jury, find the defendant, Richard Thomas Casanova, guilty of the felony offense of violation of certain court orders in a family violence case as charged in the indictment. Does anyone wish to have the jury poll state? Defense?
Yes, Your Honor.
All right, ladies and gentlemen, I'm going to ask you if this is your verdict. If this is your verdict, please answer yes. And we'll start at the end on the front row. Is this your verdict? Is this your verdict? Is this your verdict? Is this your verdict? Is this your verdict?
Yes.
Is this your verdict? Is this your verdict?
Yes.
Is this your verdict? Is this your verdict?
Yes.
Is this your verdict? That's okay. Is this your verdict? And is this your verdict? All right, ladies and gentlemen, I'm going to have Deputy Laura take you back to the juror room, and I'll come back and speak with you briefly. All right, everyone, please rise for the jurors. All right, everyone, please be seated. All right, Mr. Casanova, you decided to come to the court for punishment. This is my options for both parties. All right, you can waive PSI. If you want to waive the PSI, what will end up happening is I can call you back on December 19th, and you can bring whatever witnesses either side would like to bring, and I can make my decision based upon that. If you all wish to proceed with the PSI, it's taking 8 weeks. Yes.
I have a vacation letter on file. I start my vacation the 17th.
All right. If you want to do it before then, you're more than welcome to do it before then. Is that what you're requesting? Sure.
You gotta come back as soon as possible.
All right. And when is your vacation, counsel?
It starts the 17th.
All right. If you want to bring it back the week of December 9th, the 12th maybe, if that will give you time to have witnesses, if you want witnesses present.
Could I actually come back on the 16th? Your Honor, I have to be here anyway.
Yes.
Okay.
Yes. So what will end up happening, Mr. Casanova, is we'll come back on December 16th. If there are witnesses, I will listen to witnesses. I've already heard the trial and I listened to the trial intently, as I always do, of course. And then I'll make a decision on the sentence at that time. All right. Is there anything else? All right. And counsel, do you need to speak with your client as far as any witnesses he would like to have? All right. So we're going to go on a short recess. Let me speak with the jurors, and counsel, if you would like to speak to the jurors, you all are more than welcome to do so after I speak with them. Okay.
So
Lucky to be alive.
that's what I said. I said, it's a miracle.
All right, everyone, just,
I know you were supposed to come this afternoon, but I'm at a break where I have a moment now, so I thought we'd try to catch you while we had a minute.
okay, where's your client?
Oh. Let me find it.
All right, thank you.
You could talk to the jurors.
Yes, you may want to ask them questions. They're back there.
Yeah, they're still there.
Yes, they're in the back.
Otherwise, can I be excused, Your Honor?
Yes.
How you doing? Just getting.
Judge, I think we have to TR.
All right, just let me put this in the system.
Daryl.
Daryl, Cindy.
Yes.
And.
Okay. Judge, I think you have a kick out of just saying that we spend the night during fiesta.
Hey, I wasn't here. I was celebrating mom.
But you could have given us a break.
Oh, was it me or was it Judge Angelini?
You could have not reserved Judge Angelini.
Ooh.
1, 2, 4. That's it. Oh, yes.
Let me find out where it is. I'll find out right now.
You're too.
Lindsay, I'm gonna walk while I look for it. Lindsay, I'll be back. I'm gonna walk while I look for it.
All right, Jennifer Hernandez.
Defense counsel needed to visit another court for another client.
All right, thank you. All right, who is here on Lisa Pryor? And counsel, are you ready to proceed on this motion to revoke?
Yes, Your Honor, we're ready.
Who's the prosecutor?
Mr. Edelman.
All right. Court is calling 2023 CR 7272 State versus Lisa Godwin Pryor. Can I have parties announced for the record for the state? Defense?
Renee Munoz.
And are you Miss Pryor?
Yes.
All right, can I have a file stamp for a motion to revoke, please? No problem. All right, Ms. Pryor, did you review the documents entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney?
Yes.
Did you understand it?
Yes.
Are you the same Lisa Godwin Pryor who's placed on deferred adjudication in 2023 CR 7272 for the offense of tampering with the government record on October 16, 2023 for a period of 3 years? Is that you?
Right.
All right, state.
In Bear County, Texas, the defendant Lisa Godwin Pryor did then and there fail to report to the supervision officer as directed for the months of June and July 2024 in violation of condition number 4.
How do you plead to that? True or not true?
True.
State?
Deny the MTR.
No. Do you waive the other allegations?
Apologies, Your Honor. Yes, state waives the remaining violation allegation.
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, I
Court will find violation of condition number 4 true. Is there a proposed agreement?
Yes, referral to felony drug court, 90 sober support meetings in 90 days. And if Ms. Godwin is not accepted into felony drug court, bring her back to court, figure out what to do.
All right, so here's my question. Why is she not reporting?
If I may answer on behalf of my client, Judge.
Yes.
She was in the midst of heavy drug addiction, Your Honor. She was, at the time of her plea, our understanding, released, and she wasn't ordered to the mental health caseload, which is something we'd additionally be requesting. I think a referral for felony drug court was ordered. However,
Yes.
that never matriculated. It was never received. So there was that lapse. So she wasn't considered for it. Unfortunately, that might have slipped through the cracks on that particular occasion. In speaking with probation, it seemed to be the case that had occurred, and it seems that she was let out into the community without the tools necessary to be successful on her probation. If you notice in the motion to revoke, she was actually showing up to go test, and there's numerous positives for methamphetamine.
Okay, so I ordered the MIC evaluation and I ordered a referral to felony drug court.
Yes, Your Honor.
So you're saying there was some breakdown in communication somewhere?
That's our understanding, Judge. In speaking with Ms. Abrams, she stated that the request was made for felony drug court. However, it was not received on the felony drug court end to start the process to review. And I think she was let out. She wasn't given the access to those resources then. And she's fell into the usage, Judge. She was showing up. However, we believe that something more intensive was likely more needed for her in terms of her methamphetamine usage.
Was the MIC evaluation done?
Did you ever?
Yes, ma'am.
The MIC evaluation was done. Okay. You attended that?
Oh, just one second. Ms. Abrams, what was the result of the MIC evaluation?
Michael.
Okay. So she's on mental supervision caseload.
That's my my apologies on that, Your Honor. She
Oh, no
said she
problem.
hadn't been on that. So it seems like she did the evaluation. But in relation to the substance use, Judge, that's where I think a lot of these issues stem from. She has violations for testing positive, and there's nothing in my purview that's criminal based, but more so her needing help and treatments. The underlying offense is, I believe, a tampering. It's not nothing violent in nature. I don't seem to her to be aggressive or violent or a threat or danger to the community, but rather the red flags indicative of her needing substance use help. Further, Judge, we also, when she was in custody,
I'll be there shortly.
asked PICU, Population Impact Control Unit for Bexar County, to screen her, and they deemed her eligible for what's called Pay It Forward at Haven for Hope, which is a sober living.
Yes.
And also, as the court's aware, transition into a permanent housing as she would have housing issues. It's our understanding that probation would more so see if she could qualify for felony drug court, and perhaps if she doesn't, hopefully maybe do that Pay It Forward program at Haven for Hope, which she is willing to abide by, Judge. But all these things are indicative of the fact that I think that she needs help and treatments over just straight incarceration.
All right. There was something you wanted to say to the court? I saw you raising your hand.
Oh, I didn't know that it had already
Well, just
been.
one second. I'll need to put you under oath. Can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. State your name for the record.
Lisa Pryor.
All right, what did you wish to say?
Oh, I just was confused on being the probation part, mental health probation,
Okay,
because from what I knew, I wasn't in that caseload yet.
all right. Probation, what is your recommendation?
Judge, being that we did not have a felony drug court evaluation, I would like to see what the outcome of that evaluation is. The 90 sober support meetings in 90 days, and if not accepted into felony drug court, move forward with the pay it forward at Haven for Hope.
All right, is there a need for an updated TAP evaluation or no?
That's a good question. I wonder when the last time one was done for her.
There was a TAP revision done April. It would not hurt to go ahead and get an updated TAP. Judge.
All right, court will follow your agreement. The court is going to deny the motion, alter and amend conditions to include the following in custody. There's to be a referral to felony drug court. And there's to be a TAP evaluation in custody. If she's not accepted in felony drug court, then we'll have this case brought back here because I want to see what the TAP evaluation says.
That's right.
Then there's going to be 90 sober meetings in 90 days. And probation, you said she was approved for MIC. She doesn't think she's on the MIC caseload, if you can confirm that.
Yes, Judge.
And so I will say MIC, although she should still already be on MIC supervision, but I'm going to request MIC supervision.
That's right.
Is there anything else you need from the court to be successful? Let me see, when is her expiration date? Okay. Is there anything else from either side? All right, we can go off the record. Here's the thing. You can't get in your throes of addiction, stop reporting, don't show up, because then what ends up happening, you're looking at revocation. And you're looking, in this case, at potentially 10 years in the prison. Do you understand? If there's an issue, you need to let probation know. If you feel as though you're about to start using, let probation know. And when you do those sober meetings, you need to get a sponsor. Do you understand? All right, good luck to you.
Thank you, Honor.
All right, everyone, I'm going to take 5 minutes. I'll be All right, Mr. White? Marshall White? Oh, okay,
He's looking for his gloves, Judge.
all righty.
Boxing gloves or winter gloves.
All right, are you all ready on Jennifer Hernandez?
Yeah.
All right. Court is calling 2022 CR 11622, State of Texas versus Jennifer Amber Hernandez. Could I have parties announced for the record for the state?
Paris Edelman.
Defense?
Warren Wolf from Ms. Hernandez.
And are you Jennifer Hernandez? Yes. Right. Did you review the documents entitled Motion to Revoke Community Supervision and State's Motion to Supplement Pending Motion to Revoke Probation with your attorney?
Yes.
Did you understand it?
Yes, John.
Are you the same Jennifer Amber Hernandez who was placed on community supervision in 2022 CR 11622 for the offense of unauthorized use of a vehicle on April 10th, 2023 for a term of 2 years? Is that you?
Yes, John.
All right, state.
In Bear County, Texas, the defendant Jennifer Amber Hernandez did then and there fail to report to the supervision officer as directed for the months of July, August, September, October, November, December 2023, January, February, March, April, May, June, July, August, September, October 2024 in violation of condition number 4.
How do you plead to that? True or not true? I'm sorry.
State waives the remaining violation allegations.
Any objections?
None.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, and sentence you up to 2 years in the state jail facility and up to $1,000 fine?
Yes, John.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, John.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Amend conditions for updated TAP recommendations, which are to restart Alpha Home Program.
All right, why would I go along with that? She's been missing. And didn't I previously order Alpha Home?
There were some issues, Judge. She is in a different place at this moment as far as.
What were the
her-
issues with Alpha Home? You want to raise your right hand? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, John.
You can lower your hand, state your name for the record.
Jennifer Amber Hernandez.
All right, I ordered her to be released to Alpha Home only. So first question, were you released to Alpha Home?
Yes, John.
All right, so why were you
I
not unsuccessful?
I started using again after I was there. It was really a good program. I got in touch with the people I shouldn't have got in touch with, and I relapsed.
All right, I don't see why I should follow this agreement because she was in a good program. This is not a situation where there's some miscommunications on my orders. She was ordered into Alpha Home. I did not allow her to be released to go on her own to Alpha Home. What I did was I ordered her to be transferred from custody to Alpha Home. She was. And then what the state has just read to me, she has been missing since July of 2023. So I don't understand why I should continue her.
Well, Judge, I've had an opportunity to talk with her about her situation now. She's a little older and a little wiser, and she understands her situation. From the beginning, when I first talked to her, she was reaching out for help. She's serious about it. Sometimes it doesn't ring true, and I appreciate, Judge, your willingness to help her at that time. Drugs are hard. You know the story, that it's sometimes difficult to face, and it takes, you gotta hit rock bottom, it's gotta hit you. Sitting in jail, she's come to that understanding, that place where I think she's in a position where she understands that she needs help. That was the first thing she ever said to me when I spoke with her.
Yes, when I was out there in the previous movie, I learned a lot and it was way harder on me. I had like lost myself. I thought I was losing my mental state. Using like it was to the point where like I started feeling like I was crazy. And I was in the streets. My mom didn't, I never
I'm
had.
sorry, you were where?
In the street, like in the streets. I was living from like house to house or whatever, and I kind of learned this past time, like I'm gonna like I'm not willing to do that again. Like I don't want to do that. I hit rock bottom. When I came in here, I was like, you could see my bones from my face. I don't want to go through that again. I kind of it wasn't me when I came back in here. But I really want help. They always end up sending me to like lockdown facilities, but I really love the Alpha Home. The Alpha Home was
Oh, let me just tell you, you're not going back to the Alpha Home.
okay.
That's out of the question.
Yes, ma'am.
You're going to a lockdown facility because obviously being at the Alpha Home, if I were to continue, you would be going to a lockdown facility. These are your choices. And do you deserve these choices I'm about to give you? Probably not, because you've been missing since 2023. But I'm taking in consideration the nature of the case that you're on probation for and the fact that you have someone who needs their restitution paid. So this is what's going to happen. You are either going inpatient treatment at a lockdown facility or felony drug court, or I can sentence you today and I'll sentence you to 1 year in the state jail facility. Those are your choices. Those are the only choices you have. Do not ask me about outpatient treatment. Do not ask me if you can do it on your own. Those are the only choices you have. All right. Probation. This is what's going to happen. She's pled true to violation of condition number 4. I see that her probation length is for 5 years.
That's less than a year left on probation, Judge.
It's been probation in 23.
Yeah.
5 years would be 28.
Yes.
Judge, she expires April 2025. The underlying sentence was 5 years.
Yes, she should be from 2023. That's when she was placed on probation for 5 years.
She was placed on probation for 2 terms,
No.
2 years,
I placed her on probation for 5 years.
and that would be 20 years.
Okay.
Judge, what's notated was, it was state jail, suspended and probated for 5 years,
Yes.
starting on April 10th, 2023. So our system seems to be incorrect.
Okay. All right. then.
So she would not expire until 2028.
All right. And I see that your recommendation, at least probation's recommendation, the office is recommending that she be continued. This is what the court will do. Yes. Yeah, I don't know who's making these recommendations. She's been gone since 2023.
Yes, Judge.
All right. So I'm finding number 4 true. I'm going to deny the motion. I don't know if you're going to be successful on this or not. I'm going to alternate amend conditions. Do you need an updated TAP or can I send her to safety?
Judge, did a top evaluation. There are a couple of offenses that are going to prohibit her into any lockdown facility unless those are taken into consideration.
All right, if you all can step back and see what offenses probation is speaking of, because if she has open cases, there's an
Familiar
issue.
with those.
What is the open case?
Assault peace officer, harassment public servant, Your Honor.
All right, and so when y'all are making these offers, why do you all think that I do not need to know this? Because nobody told me that she has open pending cases. What is happening with these I just been given this. What is happening with these open pending cases?
They're subject to review and they haven't been presented to the grand jury. We talked about this the last time we were here. We were not gonna, I know you didn't want to get involved in plea negotiations.
Because there was supposed to be a contested hearing today.
That was on the MTR because of the circumstances, but we've come to an agreement. Different prosecutor, we were able to have a meeting of the minds.
And Judge, the officer, supervising officer is present today.
Did y'all even confer with the supervising officer before y'all reach y'all agreement? Did anybody talk to the person who was subpoenaed to be here?
I didn't speak.
Why would you all approach me? And I keep saying, talk to probation, and this is a contested hearing, and probation has brought this officer here who's needed back, you know, looking at other people. You all need to go confer with her. Go confer with her.
Go have a seat, ma'am.
MTR. They're okay.
Okay. Darrell Payne?
Mr. Payne? That's.
And I'm sorry, did you have a chance to confer with probation?
I have.
Okay. Who's the prosecutor? Is it Edelman? All right, just 1 second, Mr. Payne, if you have a seat, the prosecutor went outside. He'll be right back. Or if you want to confer with Jason, you can.
I've got a boost post we're gonna need approach, but Megan is the prosecutor. We're still looking for some ballistics. She's contact lab. Okay. And the lab person's supposed to call her back to get her behind. But she didn't have it.
Judge, we can approach it.
All right, he has a motion to revoke with Mr. Payne.
Oh, he has a motion to revoke?
Yes.
Oh, okay.
I think that's good. See, just circle with you. I'm sorry. Oh, okay. Oh, okay. I thought you dealt with it. I saw it.
Who's this one?
This is from Bexar.
Thank you, Judge.
Oh, okay. Well, I'm back.
And Norma, call Roberto Ambrosino. He needs to be here. Who's here on Ethan Rosales? All right, we're waiting for your attorney. All right, court is calling 2024 CR 3511, State of Texas versus Daryl Payne. Mr. Payne, if you'll come down. Could I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Ron Ross.
And are you Mr. Payne?
Good morning, ma'am.
Good morning. All right, Mr. Payne, did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am, I understood.
Are you the same Daryl Avery Payne who was placed on deferred adjudication in 2024 CR 3511 for the offense of harassment of a public servant on July 29, 2024
Yes,
for a
ma'am.
period of 5 years?
Yes, ma'am.
State?
Yes, Your Honor. Violated condition number 4 in Bear County, Texas. The defendant Daryl Avery Payne did then and there failed to report to the supervision officer for the month of September 2024, a violation of condition number 4.
How do you plead to that? True or not true?
True, true.
Your Honor, we'll waive the remaining violated conditions.
Any objections to the waivers?
No objections, Judge.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison
Yes, ma'am.
and up to $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there proposed agreement?
There is, Your Honor, and is to deny the motion, alter and amend its conditions to include state ISF cognitive track. And the state is rejecting that other case and will be rejecting that today, Your Honor.
He's got a brand new,
Assault case.
Pre-file case. It's assault on a peace officer. It's case number 2024 PF 16955.
All right. And is that the case that's being rejected?
Yes, ma'am.
Yes, it will be, Judge. Just have Mr. Edelman is stepped out and he will be filling that out.
All right.
Judge, that is agreement. Mr. Payne has severe mental health issues.
Yes.
He's been to hospital, state hospital, Laurel Ridge.
No, I understand that.
We're
So-
trying to make sure he's got some mental health treatment.
So here's my question. I don't understand how placing him in ISF for cognitive is going to help with the mental health issues.
Isn't that what that's for, mental health? And
Not necessarily. I'm aware of his mental health issues. His brother came into court before, stated that he would be living with his brother. So the issue we have with your client is there's major mental health issues, but also he doesn't have a residence. Probation, you want to weigh in?
Judge,
Just one moment, just give me a second.
Judge, there are major mental health issues. From my understanding, he is still welcome to live with his brother.
Mhm.
He does not meet the criteria for other programs that we have. And state ISF cognitive, we felt would be the best option to ensure that he's getting the medication that he needs and to address maybe some cognitive issues. I don't know necessarily that he will be qualified for it just yet, but that's our best case. Only because I would really like him to go through the evaluation portion of it. I've worked with his brother when he's come in to get him back on track with the Center for Health Services. Me personally, and it does seem that when Mr. Payne doesn't want to go, he just doesn't go, and then he disappears for a couple of days. So we really do want to make sure that he gets the help that he needs. He hasn't been on probation very long for our MIG caseload to further, work with him.
All
Well,
right.
it's my understanding that he was living with his brother part of the time. Part of the things he got off his meds. And I guess he left the house because of that. If he gets back on meds and gets back straight, it's my understanding he can go back and live with his brother. And that's from what I understand, that from what I've been able to ascertain. I don't know. I'm not telling you the brother hasn't told me that because I don't know, but reading what the probation has and talking to my client, I think that's the case.
All right, Mr. Payne,
Yeah.
it appears there was something that you wanted to say.
But I was, when I was in court the last time, I wasn't able to hardly walk. And when I went home, my brother told me he wanted me to do chores. And I wasn't, I was weak. And that's one reason why I left. It was my fault because I should be able to do chores right. I wasn't able to walk, I'm still weak. I'm gaining my strength day by day.
All right. So, does everyone think his brother is the best placement for him, or we just say that's the only placement for him? Is he receiving are you receiving SSI?
Yeah.
All right, so
I don't know, Judge, and I don't even know if he's gonna qualify. Well, I think what we're gonna do is, I talked about just resetting this and have him evaluated. Probation said, well, that would kick him at the end. Let's just start the process and come back in maybe 30 days to see if he doesn't qualify, then we'll have to go to something else. But whether that's the best place, I don't really know for sure.
all right, this is what the court is going to do. Court will follow your agreement. The court is going to deny the motion. Court will note that 2024 PF 1699 is being rejected. Court is going to alter and amend conditions to include state ISF cognitive. There's going to be partial GPS waive fees that can be through the jail, and that'll be until further notice. Re-refer to Center for Healthcare Services. If he does not qualify for ISF, then we'll bring this back. And counsel, if you could check with managed assigned counsel, or either if you go to the community court, they may have a different placement for him for housing that will address the mental health issues as well as everything else. Because if he's receiving SSI, and if he can't walk, which each time he comes to court, it appears that he's struggling health-wise, then maybe he can't do chores. I don't know. But I don't know if being at his brother's home is the best placement for him or not.
Okay. I was taking my meds. I was taking my meds. I made the mistake of leaving. My brother didn't tell me to leave.
Okay.
I left on my own because I was weak at the time, and I'm gaining my strength. My brother did everything for me. He fed me. He washed my clothes. He washed the dishes. He took me to the Center for Healthcare Service.
Okay.
On East Houston and South Palmetto.
All right, just 1 second. Yes.
Judge, I would also ask that we put on there after release from state ISF, the MIC and Genesis program.
All right. So we include the MIC and Genesis program. And here's the thing, sir. If there's some issue with your brother and you feel you need to leave.
I ain't leaving no more.
No. I mean, here's the thing. That's happened last time. That's why we're here now, is because you stop taking your medications, you leave. You can't do that. When you stop taking your medications, you know what ends up happening?
Yeah.
You pick up a new case.
Yes,
and you
ma'am.
end up back in custody.
Yes, ma'am.
And let me explain something to you. You may end up in custody and end up before a different judge with a different prosecutor, a different attorney, and you could find yourself in prison.
Yes, ma'am. I understand.
All right.
Miss Stephanie.
All right.
Can I have another chance?
Yes.
Thank you.
You're welcome. All right. Thank you.
Yes, I promise, man. I'm gonna obey everything. I
When you
promise.
get out of this program, they're gonna put you another MIG program. They're gonna follow. They're gonna keep helping with mental health. You just need to keep doing what you gotta
In
do.
2004, I made 7 years probation.
Okay.
I can do it. I
Okay.
can do it, Stephanie.
All right. Here's the thing. If there's an issue with your brother, you can come to court and we'll address that, but you can't just
Yes, ma'am.
leave.
Yes, ma'am.
All right. Good luck to you.
Good luck,
you
good luck.
very much,
Good luck,
Captain.
sir.
You're welcome.
Honorable Judge Jeffrey.
Oh, thank you so much.
Thank you, Your Honor.
I'm also ready on Bustos. We got approaching.
All right, can I see the file on Bustos, please?
Put that up there, Judge.
Oh, and here's this. Bustos. All right, Jason Giovanni Bustos.
Morning, Your Honor.
Good morning. All right, what is happening on this case?
Judge, state has been trying to get the ballistics done on this,
Okay.
and I guess they're behind. Megan has contacted the lab this morning, and she talked to, I don't know who it was she talked to, I don't know if it wasn't a secretary, it could have been, I think it's a secretary. She was gonna talk to the lab person and come back with her with a timetable, what they thought, how long it's gonna take to get it finished. They've done part of the ballistics. We got to report some of it, but it's not completed.
All right,
And
Norbert,
so
recall this for January 13th.
that's what we're gonna ask for. Okay, thank you very much.
Thank you, Judge.
All right, we'll be back on January 13th. Do you have any questions? Yes, what's your question?
No, I don't have a question.
Okay, all right, thank you.
And that's for discovery.
Yes. Ask more. I'm sorry, your attorney's not here. Oh, I didn't see you. All right, come down. You know, it was like the movie where you're moving in and out of the shadows. I couldn't see you.
I'm trying to hide it, Judge.
All right, I appreciate that.
Apparently, I'm doing a good job.
All right, so where are we on this case?
Okay, Judge, you, I think reset it today because last time we were here, I requested an investigator.
Yes.
So I
Oh,
filed
and
them
that's been done.
That has been done, exactly.
And then there
Now
was
we
an
just need-
issue with my understanding, there was no crash report exists. Have you completed the download of discovery?
I'm not, I think I have, Judge, I'm not sure.
All right.
I just forget.
So have you turned over all discovery?
Everything that we have just been updated, uploaded.
All right, did you tender an offer?
We have tendered an offer.
All right,
I think defense wanted to see if they could get some time for the investigator to do his work.
Yes, my investigator needs some time just to check some things out.
all right. So we're coming back for a plea deadline. How old are you? All right, we're coming back for a plea deadline date. Norma, if you could put this for January 23rd.
Okay.
All right, is there anything else?
Nothing else?
All right, and if y'all could sign the acknowledgement of discovery. All right, thank you. Yeah,
Thank you, Judge.
you're welcome. And I'm sorry, Norma, what date did we give Mr. Casanova?
December 16th.
All right, thank you. Ethan Rosales, the attorney for Ethan Rosales.
Yes, sir.
Mr. Marshall. Not your judge.
I sent him a text message.
Is Larry Smith on the docket? Can you call Mr.?
He's doing the fees at 26.
All right. All right, Jennifer Hernandez. All right, so did you all speak with probation?
We did, Your Honor.
All right, so this is what I'm gonna have y'all do. I'm gonna have y'all come back at 1:30. I need to think on this, on what I'm gonna do with her and what would be appropriate. All right, everybody's staring at me. I mean, that's
You
what I do.
haven't said that we could go, Your Honor.
Pardon?
You haven't.
Yes, oh,
asked us.
y'all can be excused till 1:30. Thank you. Ethan Rosales.
Did not find my gloves.
So where are we on discovery?
Judge, we signed an acknowledgement. It should be in there. We
Yes.
signed it yesterday.
All right, thank you. So has an offer been tendered?
There has been.
All right, how old are you?
22.
22. All right, I'll set this for a pre-deadline date. Council, do you have vacation in?
No, I don't, Judge, not yet anyway.
All right, is December, I can do December 16th, 17th, or 19th. That's Monday, Tuesday, and the 19th is a Thursday.
19th is fine with me, Judge.
All right, so your plea deadline date is going to be December 19th. You need to let me know whether or not you're reached an agreement. If not, your next court date is going to be for jury trial. Do you understand?
Yes.
All right, you have any questions?
No.
All right, once you sign the reset form, you're excused.
Just have a seat back there, please.
Counsel,
Yes,
you
Judge.
said you lost your gloves.
I did. I mean, I had my gloves this morning and,
You know which court you, if you want,
I was
can.
in this court, but I was also in the 437. They don't have cameras in the 437,
Oh.
but go ahead.
What color are the gloves?
Black. They're your typical black OJ type gloves. They are. That's what they are, and they're not gonna fit everybody. You know.
Okay.
You know, they're not gonna fit everybody. You
Let me
know,
ask you this, do you want me to send an email to the courts and they can see if they can find them?
that'd be fine. I mean, it's literally an APB out for, you know, with the sheriff's office, you know, downstairs. But yeah, I mean, because I've had those gloves at least. I hate losing. I know nobody likes losing anything, but I probably had those gloves at least 10 years.
You know, I didn't lose, someone stole one of my umbrellas.
And that's kind of what I think is going on here.
Uh-huh.
You know, you know, they saw me drop them, you know, instead of saying, hey, you know, you dropped your gloves.
And you haven't been on the civil side, correct?
I did go on the civil side, like I told you, but.
No. Bye-bye.
I-
Oh, thank you. So was it civil district court?
Yeah, I was in the 45th. I went back, I retraced all my steps, you know, since I realized I didn't have them.
Oh, the reason why I was asking that, because I'll include them in an email.
That's fine. I appreciate that, Judge.
Welcome.
The lost you found? Is there a
Yeah,
lost you found?
I've checked, I'll put the APB out. Thank you.
You're welcome.
Yes.
Judge Michael, have you on Zoom? Did I say 26?
Yes.
Still here? Nope, we left without you. I'll see you again.
Jennifer. Wonder.
And let me see the client for Ambrosino, please, that file.
Amber who?
Robert Ambrosino.
Judge,
Yes.
will you need
That's the okay.
the CSO back at 1:30 or
Yes,
what's the
please.
case number?
Tell her she can appear by Zoom.
Okay.
Thank you.
TAEGLE, I think.
Yes, ma'am.
Okay.
1.2 CR. 7737 alpha.
Okay, beautiful. We like, it's a Chrome. It's that. They're very. Oh my God, my. Yeah.
All right, you can take this one. It's coming back at 1:30. All right, Andrea Castillo. Can you, Deputy Laura, when the other deputy comes back, can you have them make an announcement in the hallway for them? Yes. All right, Jason, are you available to take this up for someone who didn't show for court?
Sure, yes, yes.
All right, court is calling 2019 CR 5003W State versus Andrea Castillo. This case was recalled from yesterday. The defendant was a no-show as of 4:49 PM on December 3rd. Deputy Laura, did you make an announcement for the defendant?
Yes, Your Honor, I did. Did she?
And was there an announcement?
I announced it, but she is not in the hallway.
All right, and for the state?
Jason Gary, of the state, Your Honor, we're requesting either a bond forfeiture or a judge's warrant.
All right, the court will issue a bond forfeiture and remand her without bond. If she makes an appearance, the court will reconsider. And I'm sorry, back on the record. Yeah, for the record, it is 11:57 AM. Thank you. Yeah.
That's right.
Oh, we just did your case. We'll redo it since you're here. Could I see that file back, please?
Which one? I thought she wasn't.
No, she's not.
Oh.
But I like to
That's
have
you?
her.
Oh.
Yes.
Oh, okay. Just for fun or what?
All right, we're gonna go back on the record in 2019 CR 5003W State versus Andrea Castillo for the state
Andrew Harris, Edelman.
defense.
Roberto Ambrosino?
All right, your client has not made an appearance. The deputy called for the client in the hallway. There was no response. It is currently 8:58 AM. Have you had any contact with your client?
I have not been able to make contact with her, Your Honor. I was also here yesterday.
Yes.
Wasn't present.
All right, then the court is going to again issue the bond forfeiture and remand your client without bond. If your client makes an appearance, the court will reconsider. All
Thank
right,
you.
Thank you.
Thank you.
So how are the Steelers doing? We know how the
They're doing
Cowboys are
Great.
doing.
They're doing great. Yeah, they're doing great. I was at the Commanders game a
Mhm.
couple weeks ago, so that was fun.
Ah,
That
So-
stadium is bad.
But here's the thing, and I know what Bashan is gonna say, but I don't know what you're gonna say. So how far are they gonna go?
I think they can do it.
I think.
Well,
they
what
can
does
get
that mean?
I think they can
do
win it. They can win it all. I think they can.
So you're saying,
With Russell Wilson, the way he's playing, and I mean, they always had the defense. It was just quarterback. They haven't had a quarterback since Ben retired, but
well, they say,
he's looked really good.
well, but Sean, they say that Kendrick Lamar is going to be performing at halftime. I wonder if he's going to have Sierra come down to perform as well. That would be fun. That would be shocking and funny.
I had to wonder whenever they signed him, like, how happy is she going to be in Pittsburgh, right? It's not New York, or I guess they were in Denver and Seattle. Those aren't like.
Did you see the San Francisco game where it was snowing so
I saw a
badly
little bit of it.
and the fans had to clean out their own seats? And I think they interviewed the San Francisco
They always do that.
coach at close to halftime. He's like, we're not winning this game unless we change things around. Yeah.
They always do that there in Buffalo. They always like invite people from the community, and I guess they go and they do it.
So somebody made an announcement. They said, if it's not safe to be on the roads, how is it safe for the fans to come to the game? I don't know the answer to that question.
I saw some posts that I guess someone actually didn't have tickets to the game and was from Ohio and actually just drove to Buffalo just to shovel. And people, the
my
NFL can make
gosh.
people do crazy things. Can you imagine? I would never do that.
Oh, I wouldn't either. I'd be like that.
And they don't even give them free tickets or anything. I think they pay them like $15 an hour.
You know what? That's similar to me. If I go to a concert and the singer wants me to start singing, can I get a discount on my tickets? Because now I'm a part of the show.
Yeah, they always do that, and it's always like cringe.
Well, have a great one.
Okay, you too.
All right,
See ya.
bye-bye. Oh, you're excused.
Are we going to take up Jennifer Tagle before the court?
Oh,
goes on
yes, come
break?
forward. Yes.
Because if we are, then I might as well stay where I am.
Oh, I think you should. Unless you want to leave and get some steps in and come back.
I was gonna say the same thing. Sometimes you need that, like everyone needs the extra 5 steps.
Oh, you do.
No, Andrew doesn't.
I get exactly as many steps as I need every day.
Do you count?
I have a machine that does the counting for me.
What do you got? Jennifer Tagle,
Okay.
and you should have the certificate. It's an MTR.
All right. I try to get my steps in because you never know when the zombie apocalypse will be upon us.
Well, I'm just gonna surrender to the zombie.
Don't do
My
it.
plan.
Well, you know, I was telling you, I read the book World War Z, then I watched it. I
Uh-huh.
was like, yeah, you cannot run these zombies.
Yeah, exactly.
People are changing the rules.
Yeah.
I'm like, zombies are supposed to be slow. Regardless of what they
reality.
said in Twilight's, vampires are not supposed to glow and walk around in the sun
That's true.
unless you are, what's his name?
Robert Pattinson.
No, not Robert Pattinson. The guy who's the day walker.
Oh, I don't know.
Blade, yeah.
Oh,
Unless
Blade,
it's
he
case.
was great.
Yeah.
Yeah.
Otherwise, normal vampires just don't do that.
That's true.
Supernatural
Tom
vampires
Cruise was
were
a great vampire. Tom Cruise was a great vampire in Interview with the
I don't know, the hair, I just couldn't
Yeah.
stop looking at the hair. It's like,
Okay.
come on, Tom.
And Rice said he was a great Lestat, so he was a great Lestat.
There you go.
I don't
never
know.
read
Have
the
you
book.
seen the series I think it's on A&E?
No, but I've heard it's very good.
It is.
I think
Is
it's
it
on
A&E?
AMC.
AMC?
AMC.
Okay,
Yeah,
Yeah.
Interview with
Oh.
the Vampire adaptation with Eric Bogosian.
yes.
I'll have to watch it.
And let me just tell you,
Really good.
it is. Now that person, you can say, oh, okay, that's the stuff.
Vampire.
All right, we're going to go on the record, 2022 CR 7737A, State versus Jennifer Tagle. Can I have parties announced for the record?
Andrew Harris Edelman for the state.
Lauren Lefton from Miss Tagle.
And are you Ms. Tagle?
Yes, ma'am.
Did you review the documents entitled Motion to Revoke Community Supervision and First Amended Motion to Revoke Community Supervision with your attorney?
Yes, ma'am.
Did you understand it?
Yes.
Are you the same Jennifer Tagle who was placed on community supervision in 2022 CR 7737A for the offense of credit debit card abuse on October 20th, 2022 for a term of 3 years? Is that you?
Yes, ma'am.
All right, state.
In Bexar County, Texas, the defendant Jennifer Tagle did then and there fail to report to the supervision officer as directed for the months of October and November 2023, violation of condition number 4.
How do you plead to that? True or not true?
State state waives the remaining violation allegations, Your Honor.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, and sentence you up to 1 year in the state jail facility and up to $1,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Revoke supervision, assess punishment at 9 months of confinement. State will take into consideration and dismiss 2 other offenses.
And what are those cost numbers?
2024 PF 19792 and 2024 CC 738184.
All right, is that your proposed agreement?
Yes, Your Honor, it is.
All right, are you asking the court to follow that agreement?
Yes, we are.
Are you?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
Probation,
Yes, Judge.
with regards to restitution, was there any restitution given to probation with the complainant in this case?
Double check.
Sure.
Thank you, Your Honor.
All right. No restitution amount was ever given?
No, Judge.
All right, the court is finding violation of condition number 4 true. Court will grant the motion, sentence you to 9 months in the state jail facility, take in consideration 2024 PF 19792, 2024 CC 738184, and there's to be no contact with Austin Galan, Galan. And the court will give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. You're gonna have to do better. Otherwise, you're gonna find yourself in and out of custody, wasting your life away. You understand?
Your Honor, before we're excused, may I approach?
Yes.
Thank you.
If there's a drug or alcohol issue with you and you feel that there's no place you can go when you are released, you can come back to this court. If I'm still here, I'll direct you to a place to go. You understand?
Yes, ma'am.
All right, good luck to you.
And she does have an involved family, so hopefully they'll
Yeah.
provide a support system also.
All right, thank you.
All right, thank you.
All right, good
Thank you
seeing
for
you. Have a
taking
good
us.
one.
Good seeing you.
Sure.
Thank you, Judge.
As marked.
Steelers aren't gonna make it though.
Here's one.
The Steelers are not gonna make it.
Oh, well, you
Ooh,
talked to
we-
Bashan about
They-
that.
They've been
Oh, can
struggling
you
in the
file
red
this for
zone.
me?
Most of their points come from field goals.
I don't need to take that downstairs.
No, I'll take care of it. up here. Well,
The misdemeanor.
this one, you'll have to take downstairs. This one I'll take.
Thank you.
All right, thank you.
No, they've been struggling in the red zone. Most of their points come from field goals. They've been playing a lot better recently, but
Oh, you need to tell that to Bashan.
just a matter before the Ravens catch up. But against the Bills,
Oh, Bashan?
I don't pay attention to naysayers.
against the Bills and the Chiefs, Steelers. And the only reason the Ravens have been losing is because their kicker has been slacking on field goals.
That's the only comment. Oh, okay, making those types of comments.
Is there?
No, I know, yeah, that is. Ouch.
Larry Smith?
President Judge, sorry for the delay. I was stuck in the G26.
Deputy Law, this is yours. Oh. All right, so we need cell phone update, is that correct?
Yes.
All right, what's the update on the cell phone?
Your Honor, the update, I have spoken with the detective who came and collected the cell phone. He was able to turn it on. He was able to get into the phone with the passcode provided. However, my understanding was that defense and the state both wanted a extraction done, and the detective has sent the phone to their forensics department to begin that extraction.
No, that's not what they wanted. The defense wanted to see what the text messages were. And if the text messages were exculpatory, then there's no need to send the phone off for extraction. But sending the phone off for extraction, that means that we'll be here in what, 3, 4, 5, 6 months from now, waiting for an extraction?
I hope not that long, Judge,
Oh,
but
no, that's what it's gonna be. We've been waiting for a cell phone extraction in other cases forever.
And Your Honor, just because we weren't sure exactly what we were looking for, the detective would have to go through the entire
No, they
phone.
said they had some dates.
And so the state's recommendation at this point would be if defense would like to go view the phone and go through them and pick out what they would like the state to review that they believe is exculpatory. But the state's position is we don't know what information is on that phone.
and
that would be
Judge, I
exculpatory.
think I do need a full extraction on the phone. I mean, I can't just assume certain things, certain facts. So I
No,
do.
I mean, if on the text messages, it says something specific,
Right, the correspondence between me.
And yet it could be 2 years worth of conversations, Judge. So it's hard to know if I can go through all that stuff.
no,
and
no, I'm
find it.
just saying. He's saying he has specific dates. Y'all can look at the specific dates. Who knows? Maybe there's a video there. But now you all have sent the cell phone off for extraction. I'm telling everybody, that's going to be 3 to 6 months. Because we've been waiting for cell phone extractions in other cases, 3 to 6 months.
And yet, I don't
And
think-
then they
I
come
don't
back.
know that we do have specific dates, Judge. Especially,
He says
It's within a time frame. It's within a year.
within
With
a
this
year,
specific
Judge.
phone.
Yeah.
And just the correspondence between me and my wife in regards to. this
Oh,
case and what
I
I'm
don't,
doing.
I don't need to know the facts of it, but if
Right.
there's something specific,
And as his counsel, Your Honor, I mean, there's specifics I need everything on that. So
all right, we'll see you back in 3 months. I don't think the cell phone is gonna be done in 3 months. So we may end up coming back in.
And Judge, well, I'd like a trial date for, as soon as possible, and hopefully get an update from SAPD, and hopefully they get 5 stars and get it done faster than 3 months.
No, I mean, because I'm telling everybody, there are other cell phone extractions that we're still waiting on. This trial that's coming up today, that cell phone extraction was over a year. So I can schedule you all back here in February. It does no good for me to bring you all back in January or any of these other dates because it's not going to be ready.
February's fine, Judge. We can get that done.
All right, Norma, put this down for February 20th. No, it's for discovery on the cell phone. All right, we'll see you all back on February 20th.
Hey, Judge.
Thank you,
welcome.
Judge.
Good seat, sir.
Thank you, Judge.
All right, we're taking our recess.
1:30, Judge?
Yes. You're welcome.
Judge.
Yes.
Yes, so here.
Oh, hey, just give me one moment. Yes. We're coming back at 1:30, and if he's not here, warrant's gonna be issued. Oh, so the people we need back. We need Jennifer Hernandez, Timothy Johnson with Jorge Canales, And that's it?
And I believe with Timothy Johnson, we should have something worked out. I just need to talk to the attorney.
All righty.